Good morning, everyone, and welcome to today's public forum. My name's Kate Simons, and I'm the chairperson of the Essential Services Commission. To start, I'd like to acknowledge the traditional owners on all of the lands wherever you are today. I pay my respects to elders past, present and emerging who may be here today. I'd also like to acknowledge the connection that Indigenous Australians hold to country and culture, particularly at this time of great uncertainty. I'd like to welcome you all to today's public forum to discuss our draft decision on the 2021 Victorian default offer. I'd also like to introduce my fellow commissioners and senior leaders from the Commission here today who are really looking forward to hearing from you all. My fellow commissioners, and please everyone feel free to put your camera on so we can see as many people as possible, and perhaps give us a wave. Satish Bajani, Simon Corden and Rebecca Billings. I'd also like to introduce our Director of Price Monitoring and Regulation, Marcus Crudden, our Senior Regulatory Manager in our Pricing Division, Dean Wickington, and the Default Offer Project Team led by Jonathan Roberts. I'd also like to make a special thank you and welcome to Ben Barnes from the Australian Energy Council. How are you going, Ben? And Patrick Sloyan from the Consumer Action Law Centre. Hi, Patrick, who will also be presenting today. I understand we've got about 80 attendees at the forum today. It's terrific to see so many faces on the screen, including representatives from retailers, embedded network operators, from government, including the Department of Treasury and Finance, the Department of Environment, Land, Water and Planning, the Australian Energy Regulator, the Australian Energy Council, and consumer advocate representatives from the Consumer Action Law Centre, VCOS and Brotherhood of St Lawrence. So great to see so many in attendance today. I'd like to warmly welcome you all today, and as we can all attest to, we're certainly living in extraordinary times, and I hope you're well and holding up under the special challenges we're all facing right now. Before we get to the agenda, just some quick housekeeping. Please be aware we are recording this forum, including any comments and questions made during the forum, either in the chat bar or on Slido. This is so we can post the video online for those who are unable to attend today's session. If you have any questions or comments while someone's talking today, please feel free to type them into the chat function or put your hand up in the Zoom chat function as well so we can respond time permitting. If you'd also like to ask a question during the presentation, please feel free to use Slido. If you head to the Slido website, and I believe that will be put into our Zoom chat as well, and enter the event code VDO21, VDO21. There's also a link in the Zoom chat, I think that's been put there now, and you can post any questions or comments there. Please keep your microphone muted when not speaking so we can avoid any feedback and background noise. Now, to today's purpose and our agenda, really today's forum is about having a conversation with you, and we're really keen to hear from you about any issues you'd like to explore further, so please post those questions to make the most of our Q&A session after the presentations this morning. At this time, I'd also like to acknowledge the work being done by the energy sector to support consumers during this very challenging and uncertain time. And this is particularly so as people experience new forms of vulnerability and existing vulnerabilities are exacerbated. Just to give you a sense of what the Commission's been doing over the past 6 months, we've held a series of community and industry roundtables to ensure we understand the immediate impact of the coronavirus pandemic. And I'm really pleased to say that there's been an openness to dialogue, a willingness to seek solutions to better protect consumers, and that's really to be commended, so thank you. These are really uncertain and difficult times, but working together, I believe we can really face this challenge head on. I'd like to also take a moment to thank retailers who are here today for providing the data we requested as part of our default offer review, which I also acknowledge takes time and effort during these challenging times. So in terms of today, you'll hear from our project manager, Jonathan Roberts, who will take you through our role in setting the Victorian default offer and our draft decision. He'll outline some key issues and remind you where you can provide further feedback after today. Then we will hear from Ben Barnes from the Australian Energy Council, representing its members, and followed by Patrick Sloyan from the Consumer Action Law Centre. We'll commence our question and answer session around 11:35 this morning before wrapping up at midday. On that note, I'm going to hand over to Jonathan, who will take you through our draft decision, and thereafter we'll go to Ben and Patrick. So thanks very much, Jonathan.
No worries. Thank you very much, Kate, for the introduction, and hello to everybody. Thanks for making the time to come along today, and a special thanks to Ben Barnes of the AEC and Patrick Sloyan of Calc for agreeing to share their views on our draft decision. So our draft decision, it pretty much uses the same approach we used in our 2020 Victorian default offer determination. I think the main differences are that we're proposing two items that we will consider variations to our decision for in the next year. These are COVID costs and network costs. Apart from that, there are also a couple of other minor changes that don't materially affect the cost stack. An example of one of those small changes relates to the fact that $300 cap contracts will no longer be available on ASX Energy from 1 July 2021. As a result, we've had to forecast cap prices for the second half of the year on the basis of the historical relationship between the contact prices for the first half and second half of the year. We've also proposed a regulatory period of 12 months, mainly due to the fact that a 6-month period is not practical because we won't have finalised network tariffs until we would be required to have made our decision for the second half of 2021. So our draft decision also acknowledges uncertainty relating to those network tariffs and also the impact of the pandemic. And to ensure that any significant cost increases or decreases are accounted for, we've proposed to use our variation mechanism for those things if necessary. So I think that's the broad strokes of the draft decision. I'll go into a little bit more detail onto those kind of key elements. But before I go on, it's also important to note that the numbers in our final decision are almost guaranteed to be different to those in the draft decision. And that's because when we make our final decision, we need to update all of the calculations in our models for the most up-to-date information available when we make our final decision. So thanks, Bobby. I think that this graph here is a good visual summary of our draft decision. It shows that our draft decision is for Victorian default offer prices to decrease. You can see in the graph that the main driver of this decrease is a forecast reduction in wholesale costs, which is then reflected in the retail operating margin and GST. If you're anything like me, it might take you a while to absorb the information in the graph. So I'll just leave it there for a few moments to marinate in your brains. That's probably enough time now. So I'll move on to talking about how that amount compares to market offers. So this graph here basically shows the bill for a 4,000 kilowatt hour residential user under the proposed Victorian default offer prices in our draft decision to market offers that were available on Victorian Energy Compare in August in the Gemini zone. So you can see the little dotted red line is the Victorian default offer, and the light blue bars are offers with discounts applied, and the grey bars above the blue offers are offers without the discounts applied. So you can see that the Victorian default offer is above most of the offers which were there, and that also reflects information that we have from the cost data that we collect from retailers. And in that information, our Victorian default offer allowances sit comfortably within the range of observed costs from the information we've received from retailers. Next slide, thanks, Bobby. The 12-month regulatory period is one of the key components of our draft decision. So in our consultation paper, given the changes to network tariffs in 2021, we asked stakeholders to consider the merits of different regulatory periods for the Victorian default offer. Our draft view is that a 6-month regulatory period isn't really workable. As mentioned before, it's not likely that we'll have network tariffs that have been approved by the AER before we would be required to make a decision by late May in 2021. In addition to this, an 18-month regulatory period is also not workable in the time we have available to us, as we need to consult on changes to the cost stack, particularly relating to wholesale costs. And given current uncertainties around the impact of the pandemic and the changes in network costs, a longer than normal regulatory period could also potentially lock in costs that are too high or too low. So as a result, we've proposed that a 12-month regulatory period is appropriate for the next VDO. That said, though, we are open to considering other regulatory period lengths that don't have the same practical drawbacks of an 18-month or 6-month regulatory period. Next, thanks, Bobby. So as I mentioned earlier, the largest change in our 2021 draft decision is that there are two things we're proposing to deal with by using our variation mechanism. The first is the AER's approval of network tariffs in May 2021. Our view is that after the current consultation process, we would not consult at great length on varying our decision to account for changes in the level of network tariffs. However, if there are significant changes to the structure of tariffs, we might consult more. We are interested in stakeholders' views about what level of further consultation in 2021 on a variation for network tariffs might be appropriate, especially considering the changes in the structure of tariffs which are being proposed by distribution network businesses and which are being considered by the AER. But of course, the longer the consultation process and more complicated it is, the longer the delay before we can ultimately vary our decision. Thanks, Bobby. So the other item which we propose to deal with using a variation mechanism is costs associated with the pandemic. So in response to our consultation paper, retailers raised concerns about increased costs due to the pandemic and the associated changes to their business models and market conditions. So I suppose the main thing that was raised among those things was the impact of bad debts. When we made our draft decision, we didn't really have enough information to justify making an ex-ante increase in retail operating costs or the allowance for that in our cost stack as a result of the pandemic. Retailers didn't provide any evidence of how their costs had changed at the total level due to the pandemic. And as a result, we did not include an ex-ante allowance. However, given the strong possibility of an increase in costs, we propose to use our variation mechanism to vary our determination if necessary. While we didn't include an ex-ante allowance for costs associated with the pandemic, it should also be noted that due to all of the uncertainty, we have not included a productivity factor for retail operating costs or reduced the CARC allowance, even though in previous decisions we indicated that we'd consider doing both of those things. So we're not opposed to making an ex-ante allowance for bad debt costs, but we would obviously need good evidence that such an allowance would be warranted. So the publicly available information on some of retailers' costs show that they've been able to achieve some significant savings in retail operating costs, which outweigh the increase in provisions that they've put aside for increases in bad debts. And we also note that some retailers would have seen a decrease in wholesale prices that have not been reflected in the VDO. However, obviously there are other increases in costs that we would need to consider, and potentially also other decreases. So what's really important for us in considering any changes is having information on how retailers' total costs have changed. Cherry picking only costs items where an increase has been observed isn't convincing evidence. Conversely, only considering areas where costs have decreased would be unfair as well. So what we really need is information about the changes in total costs. So convincing evidence could be comparisons of total cost data from the pandemic period to comparable periods for previous years. But we'd also need information on the individual cost categories and the causes of observed changes in each of those categories. Because, obviously costs are changing all the time, not just due to the pandemic. It could be due to retailers' continuous improvement activities. It could be for a number of other reasons, changes in technology, regulatory requirements. So we need to understand that what's causing those changes. And I guess the key reason for that is, to the extent that there have been cost increases due to the pandemic, we'd also need some evidence that those cost changes are going to continue into 2021. So I understand that, coming up with the kind of evidence that we might need in order to make a change to an allowance will pose challenges. And I know that that guidance that I just gave then is probably a little bit vague. And I guess that that's the flip side of information asymmetry. However, without knowing exactly what information you have, it's hard to be more specific than that. But we're always welcome to discussions with retailers about what information they have available and whether or not it would make persuasive evidence. So that's a brief summary of our decision. If you have any questions about any of that, I encourage you to submit your questions via Slido. And if you don't want to submit a question via Slido, you can do so via the Zoom chat. But I also encourage anyone to get in contact with the project team directly. You can either email us or give us a call if you've got our numbers. We're more than happy to discuss any questions that you might have or explain our approach and positions. So yeah, thanks again for your time, and I'll hand back over to you. Thanks, Kate.
Great, thanks very much, Jonathan. And yes, I can see some questions coming through on Slido and the group chat, so that's fabulous. And we'll get to that Q&A session shortly. And also a reminder that the draft decision is out for public feedback at the moment. You've still got time on Engage Victoria to leave a comment or make a submission until the 20th of October. So just a reminder there. I'd now like to introduce Ben Barnes from the Australian Energy Council. As you probably all know, the Australian Energy Council represents major electricity and downstream natural gas businesses operating in wholesale and retail energy markets. And the businesses AEC represent sell electricity and gas to over 10 million homes and businesses across Australia. So on that note, Ben, I'll hand over to you for your presentation. Thanks very much.
Thanks, Kate. I thought we'd go through a couple of the more challenging topics in this presentation. I think one of the things that we're starting to see is that the ESC's methodology is well embedded, and that's in terms of a normal price setting process. I think one of the challenges of the VDO, as we expect it to operate alongside market offers for some time, is that we do need to mature a bit in understanding how this will impact the competitive market in coming years. So this presentation is really going to touch on a few of the more challenging topics. I don't have answers for them. It's more about how we can better understand some of those impacts. Can I go to the next one, Bobby? So those three topics, and they do touch on things that John has just spoken about too, really identifying approaches to ensure retailers are able to recover unexpected costs. I think there's well understood methodologies in traditional monopoly regulation about overs and unders and whether it's ex ante or ex post. One of the challenges of the retail market being competitive and the ESC taking an efficient retailer approach, that really poses some additional questions. Those questions flow into the next issue as well about developing approaches in a competitive market to account for capital expenditure. Certainly we've seen a very significant regulatory reform program in Victoria that will only continue over the coming years as we move to a more two-sided market and customers become more engaged, networks implement more cost-reflective tariffs and so on. So needing to develop approaches in what is a competitive market rather than a traditional cost incurred negotiation type approach that monopoly businesses undertake. And the final point is talking about VDO timeframes and making sure that we set the timeframe, particularly for this kind of transition VDO, I'll call it, to make sure that we avoid unnecessary price changes and mitigate additional risks. Thanks, Bobby. So the first issue I wanted to talk about is that unexpected costs. And certainly the COVID pandemic has really highlighted this issue, but I don't think it's only a COVID issue. It's an issue that will keep coming up over the coming years, and we see it in network regulation with bushfires and storm damage on power lines. And I note that AusNet has recently got a approval from the AER to pass through some storm damage costs. So this is something that happens quite frequently and will presumably happen every year. The challenge in the ESC's methodology is it really talks about identifiable costs for the coming 12 months. There's no clear overs and unders mechanism where costs can be recovered ex post. So we're really trying to identify methodologies that can enable retail businesses to recover costs in a future period. I think the draft decision really highlights this point, and it raises two kind of issues. One, that some retailers have incurred costs to move customers, customer service functions into homes and moving out of the office. That's created additional costs in 2020, but those costs aren't relevant to delivering energy in 2021. So as a result, aren't going to be put into the 2021 VDO. On the flip side, we say that retailers are expected to incur additional costs, but because we can't adequately quantify them, we can't put them in the prospective ex ante issue that Jonathan raised earlier. So that really creates a really challenging position, I think, for retailers in a competitive market. The additional issue of what is an efficient cost and what is an efficient retailer is also an additional challenge. So while some retailers may manage to avoid bad debt risk, there will be others who will have very significant costs, depending on their customer base, depending on what happens with how their customers interact with them over the coming months, depending on their ability to get customers onto payment plans earlier rather than later. So the cost will vary greatly between different retailers. So I think that creates an additional challenge. Next slide. So what we'd really like to see here is that the ESC develops an approach that allows retailers in a competitive market. So that's some real clear guidance, rather than some of those points that Jono just raised about particular evidence for particular issues. I think trying to create a predictable approach and a methodology that we can use in all years to be able to identify and recover those efficient costs that are clearly unexpected when we set up the VDO. That will avoid the issues of under recovery and the damages that will clearly come to competition because of it. Next one. The second issue is about capital expenditure and recovering those costs. And as I mentioned, we've seen a very significant reform program in Victoria over recent years. We will continue to see that, no doubt. We've moved past the Thwaites recommendations, but clearly there will be further reforms in coming years that we will need to implement on the retail side. They will benefit customers, but that doesn't mean they don't come at a cost. The 5MS decision in the sorry, back one. The 5MS decision in the draft decision really highlights this scenario. Certainly retailers will incur significant costs. The ASC included in its submission a high-level industry figure. Certainly it hasn't been broken down to retailer versus generator and what those industry costs will be, but the costs across the industry to implement 5MS are very significant. However, on the flip side, the AMC identified that the benefits to implementing 5MS would outweigh those costs. So as a result, costs are efficient and should be implemented to the ultimate benefit of consumers. I think the challenge in this space is that now we need to work out how retailers are able to recover the costs that they're going to incur so as consumers to benefit on the other end. I think the additional challenge that we've seen in this decision is, again, linked back to that efficient retailer question. And while we don't know exactly what an efficient retailer is, and the ESC hasn't yet defined it, it's sort of a concept rather than a definition. It's hard to understand how the ESC will implement these costs. And while one retailer might have no implementation cost for 5MS, one retailer might have a $20 million implementation cost. So the question, I think, is how do we make sure that both of those retailers, which sometimes will have an easy implementation and some will have a challenging implementation and then vice versa on the next one, are able to adequately predict that they'll be able to recover those costs in the long term. As I mentioned, monopoly price regulation, again, slightly different. An energy business will have a clear understanding of their costs. They'll almost negotiate with a regulator to be able to recover those costs in either a future year or a past year. That doesn't work in an efficient retailer model, so keen to understand how that could work better. Next slide. And this is clear, we can skip this one, we've covered this, I think. The final issue that I wanted to talk about was about VDO change dates. The current proposal appears to suggest 4 price changes over the next 18 months. So one on 1 January, some sort of a price change on 1 July, another price VDO change on 1 January 2022, and then presumably some other sort of price change on 1 July 2022. We think there are ways to avoid that. We would like to cut out one of those price changes. Our suggestion is that we undertake a 7-month VDO and then an 11-month VDO, so as to avoid the need to have a January 2022 price change. Certainly I understand there might be technical limitations to that, and we're keen to work through how that might work in practice. But I think that would be an approach that would align price changes for VDO with market offers. So VDO market offer price changes occur 1 month after network price changes. So similarly will happen on 1 August 2021. And then we'll be able to feed that through with a 12-month VDO from there on in to the middle of 2022. The additional benefit there is that it enables retailers to better understand COVID costs. It enables us to have a shorter period where that uncertainty of the costs have not yet been shown through. And similarly, we'll be able to understand the impacts post the removal of JobKeeper and JobSeeker to enable us to better price that product. Let's go to the next slide. There are a couple of unintended consequences, I think, and really that's also about market change dates not aligning with VDO price change dates. We've certainly had rule changes in recent years where retailers are now only allowed to change market offers when there is a network price change. So if there's a January 2022 VDO change, that won't align with the market offer change. So we just need to understand how some of those issues might flow through. So that's where I wanted to leave it. You can go to the next one, which just really highlights that we think a January, August and July price change schedule might solve some of the problems that are posed. Certainly if there is a 1 July network price reset, it still requires retailers to do the price change. So it doesn't really avoid any issues for a customer. I'll leave it there. Thanks, Kate and others, and looking forward to the discussion.
Thanks very much, Ben. Some really interesting reflections and observations there for us to give some consideration to, and I've seen a number of questions pop up on Slido that pick up on the issues that you've raised, so I look forward to that discussion as well. So thank you, Ben. Now I'd like to introduce Patrick Sloan from the Consumer Action Law Centre. The Consumer Action Law Centre is a campaign-focused consumer advocacy organisation based in Melbourne. and primarily funded by the Victorian government and stems back to 2006 when it merged with Consumer Credit Legal Services. So Patrick, thanks very much for being here today, and I'll hand over to you to provide your presentation. Thanks, Patrick.
Thanks, Kate, and thanks for the ESC for letting us speak today. So these first two slides are just some information about Consumer Action's vision and purpose. I guess the main thing you need to know is that our organisation delivers financial counselling and legal advice services to Victorians, and we regularly get calls from people facing problems with energy debt. As an essential service, everyone relies on energy, and it's a problem if that energy is unaffordable or people are under-consuming and risking their health and general well-being. In most cases, these energy debts that we see are avoidable and stem from inappropriate energy offers or inadequate assistance from retailers when people need help. Just going to the next slide, Bobby. So yeah, everyone needs access to affordable energy for health, well-being, and to be able to participate actively in society. This access should not hinge on individuals' engagement with a complex and confusing marketplace like energy, and we shouldn't be ripped off if we do not or cannot engage with this market. These sentiments underpin the creation of the VDO, which is to create a simple, trusted and reasonable priced electricity option that safeguards consumers unable or unwilling to engage with this market. And we strongly support the VDO for electricity. Many of the problems in the electricity sector are also applicable to gas in our view, and we'd like to see an equivalent protection for gas customers, which I'll touch on briefly at the end. All our work at just going back a bit, Bobby. All our work at Consumer Action is informed by the experiences of Victorians that call us for assistance, and particularly people that access our financial counselling service. So in the last financial year, we had over 13,000 Victorians receive advice from financial counsellors at the National Debt Helpline, and energy is the second biggest debt issue that is raised by consumers, which continues a trend from the previous year. I think the biggest issue that we see is credit cards, so it's concerning that energy sits just behind those debts. Our data also shows that energy was raised in 1 every 10 calls for the first 6 months of this year, and we've also been tracking the impact of COVID on the community, and of those COVID-specific calls, energy forms 16%, which is concerning. People that do call us are often overwhelmed, so energy is often just one debt in amongst many other debts and problems going on in someone's life at that particular time. And we think the video, in our view, the video is something that is simple that we can advise people about, people that have a lot going on, and it works well alongside other protections such as the payment difficulty framework. And I've just put a quote there of a family violence survivor that has contacted us recently. She said, "These bills, they've killed me over the years," and she's just been in debt with this particular retailer for years, and she's never been able to get on top of that. In general, we're happy with the approach the ESC has taken in this draft decision, but we'd like to see a bit more work progress to just give us confidence that this price is fair and as well as possible. To the next slide, Bobby. So focusing on this draft decision, we're pleased to see prices decrease overall. Lower prices obviously help people, and even more so during an economic downturn like we're experiencing. The ESC has noted in its draft decision that it hasn't adjusted the VDO to reflect the impact of the pandemic, as it doesn't have sufficient info from the retailers to justify this change. At the end of the day, our view is that it's a core role of retailers to manage risk on behalf of customers. That's their job, and this includes debt risk. And we strongly support the ESC's decision not to adjust retail cost benchmarks because of the pandemic, and would also suggest that the Commission should be wary of setting a precedent that cost and risk from unplanned economic disruptions like this pandemic can simply be passed on via the video. We'd also note that many of the larger retailers have made and continue to pursue cost-saving measures within their businesses. We saw some of these spoken about in ASX, in public documents. These publicly disclosed cost savings are often greater than the forecast bad debt due to the pandemic, and we would encourage the ESC to have a look into this before the final decision is released. On the face of it, there could be room to further lower retail cost benchmarks based on these savings forecasts. In a similar vein, we strongly support the ESC applying an annual productivity factor, which is mentioned in the draft decision, although won't be applied on this occasion. This should be a no-brainer, as any for-profit business generally aims to become more efficient over time, and it's only fair that those efficiencies are passed on to consumers. Not only fair, but it's indicative of a well-functioning market. Introducing a productivity factor would make clear the regulator's intention that retail costs should fall over time, and it would be a perverse policy outcome if the VDO was simply to steadily increase over time because of inefficiencies on the part of retailers. Turning to customer acquisition and retention costs, I have to admit, when I learnt that disengaged customers on the video were charged marketing costs as part of their bill, I was pretty astounded, and even more so that it came off the back of a review that essentially said that competition was not working effectively in this market. Our organisation has done work in other markets that look at prices existing customers pay versus prices charged to new customers, for example, in banking and insurance. And research shows that existing customers tend to pay more, which is often called a loyalty tax. Knowing that retailers provide offers below the VDO, which you could see in that chart Jonathan put up earlier, you could argue the same thing is happening in the energy market, and that disengaged customers on the VDO are perhaps subsidising newer customers on lower offers. It's only fair that CARC should be increasingly scrutinised by the ESC in our view, reduced to zero as was recommended by the Fleet Review. Providing value and good service to customers should be prioritised over the constant chase to acquire customers through sporting team sponsorships, expensive TV ads and dodgy third-party comparison websites. We'd prefer retailers to be spending money on staff that can assist people, particularly those in financial hardship, rather than simply hiring more salespeople. Just to the final slide, Bobby. So just wrapping up, the video exists because there was a view in the Flex report that the competitive market wasn't working in this space. I mentioned earlier, we all need electricity, and we think the video plays a really important role in delivering more affordable electricity to some Victorians, and it really allows financial counsellors to simply provide advice to people that are facing a lot of difficulty in their life, so that they can call up a retailer, mention the VDO, and know that they're getting their price for their electricity. I'd just like to flag that we think there's some more work the ESC could do in expanding this group of people that are on the video. So, for example, we're aware that some retailers trump giving their best offer or video to all concession customers, and I think the ESC could play a role in bringing transparency to these sort of practices, perhaps in the quarterly market reports. Work like this outside of this specific price research would reinforce the video's role as an important backstop to make sure people are getting the best price. We'd also urge the ESC to conduct market analysis about the amount customers are paying more than the VDO, and in what circumstances that is happening as another step. Our understanding is that any fixed term contract that ends should now default to the VDO if the consumer doesn't engage. But we are aware that some people could be on ongoing contracts with benefit periods still in place. COVID, in our view, presents an opportunity for retailers in one view, that they can build trust with their customers and step up as good corporate citizens at this time. We are getting calls and have been getting calls over the past few months from Victorians receiving inappropriate hardship assistance, including potential breaches of the PDF, and that's just not good enough at a time like this. And just the final point, we think that a similar protection is needed for the gas market. Gas bills are arguably more confusing than electricity bills, and we're still seeing very high discounts in gas offers. And we note that the ESE has dealt with conditional discounting, like pay on time. We do feel that discounting still creates confusion, given discounts are generally tracked off each retailer's standing price. And I'll leave it there. Thank you.
Thanks very much, Patrick. Really appreciate those insights and input from the centre, and thanks for taking the time to be here today. Something you just said at the start of your presentation piqued my interest. You encouraged us to do more work to convince us that the default offer is fair. Did you want to shed a little bit more light on what you meant by that comment? Not to put you on the spot now, if you prefer to respond in to the submission process, that's fine, but I just thought that might require a little bit more sort of explanation if you were willing.
Yeah, I'm not an economist, Kate, so I won't try an answer, but we will be putting in a submission and just generally scrutinising, I guess, all the elements in that cost stack to ensure that they're as efficient as possible.
Great, thanks Patrick. Look forward to the submission from CAC, and thanks for your time today. We've got 15 minutes left. The time goes very quickly, but we really wanted to have a question and answer session now, and I've seen a number of pop up on Slido as well as our Zoom chat. So just a reminder, if you haven't already, feel free to put your hand up in Zoom to ask a question, and I'll flick to you. Go to our Slido website and use the event code VDO21, and there's a link to that in the Zoom chat, or just put your comment into the Zoom chat section as well. I'm also joined by Jonathan and Jordan too, who will be able to answer some questions as well. So first question I'd like to flick to is, there was a question anonymously of does the graph presented on the median of available market offers in Gemini's patch look the same in the other networks? Jonathan, you might be well equipped to answer that question.
Yeah, that's a pretty easy question because the answer to that is yes, we see a broadly similar outcome in the other distribution zones as we see in the Gemini zone.
Great, thanks Jonathan. This might be another one for you too. Another anonymous question. How is it possible that retailers are not providing data to the Commission when the Commission has powers to ask for data?
Well, we are receiving information from retailers and we are asking for it. The issue, I guess, here is that we're asking for historical data, and generally we try to minimise the burden of our information requests on retailers. So we tend to ask for data for years where we know that it's already been audited. In terms of information on the pandemic, given that the cost data for the last 6 months or so, only part of that has been audited and it's not full year data, it wouldn't usually fit into our standard information collection processes. And also, as I mentioned before, we're not sure exactly how retailers are accounting for their costs. And we know that there's differences between many different retailers. And so basically, given that it's in retailers' interest to provide us information on the impact of the pandemic on their costs, we would expect them to provide the evidence that we would need to make an adjustment to their to the cost categories in the VDO cost stack. So yeah, I hope that that answers the question. Did anyone else have anything to add to that particular question, or anything else relating to that that they'd want explored a little bit further? Feel free to put your hand up in Zoom.
Thanks, Jonathan. I don't think I can see any hands up in Zoom, but even we're talking about costs and data. There was another question from Sean Tan, which possibly ties in with something Ben raised in his presentation. So his question was, what specific costs are the Commission looking for from retailers relating to retail operating costs due to the pandemic? Would it be similar to what is already being provided by retailers on a voluntary basis to the Commission for Customer Debt since the start of the pandemic? Jonathan, that's probably a question for you as well.
Yeah, so I think this kind of goes back to what I said in response to the last question. And I guess in terms of the cost data that we are collecting on an annual basis, if we could receive similar information for the pandemic period and compare that to similar periods for previous years, that would be go some way to giving us the information that we need to assess the impact of the pandemic on retailers' costs. I think what would be also helpful in addition to that would be commentary and explanation of the changes in the individual cost categories, so we can get an idea of what the drivers of those changes are, whether they are associated with the pandemic or not, and whether they're going to continue into 2021. So I hope that that answers the question. If anyone wants anything clarified or wants to ask any further related questions, you know, raise your hand, or Zoom us a question or Slido us.
Thanks, Jonathan. I can't see any now, so maybe I'll move on given the interest of time, but feel free to put another chat or a hand up if any of the participants wish to. There was a question from Brian about GST actually, and I think I've got Aaron Ewan from the Energy Division online. So Aaron, this might be a question for you, but Brian's question is, why was it necessary to have retailers move to GST inclusive pricing as of 1 July 2019, when this makes the comparison by ordinary consumers more difficult to judge pricing? Talks about pensioner concession discounting, the calculations under the DHHS ruling, changing to inclusive GST pricing, manipulated the concession when it was struck under ex-GST pricing. I think you're welcoming an answer to sort of those sorts of themes and questions. Aaron, are you there?
I am there, but for some reason my video can't go on, but I can respond really briefly. So as part of our consultation back in 2018, I think this was raised, and I believe the decision actually does talk about inclusive GST pricing. Really, it's about marketing and ensuring that customers, long-standing inclusive GST pricing has been expected as part of marketing. So that was really an update to it. And concessions and how that gets accounted for was talked about in that paper. So encouraged to look back at that paper about the response and how to take into account that for billing as well.
Great, thanks very much, Aaron. There was a question about ancillary charge changes from someone anonymously, which that person who gave that question may want to flesh that out a little bit more. So please let me know, I'll put your hand up if you do. But the question, and perhaps this is one for you, Jonathan, does the Commission intend to factor in the ancillary charge changes that appear to be approved for distribution businesses as of 1 January 20?
I'd probably need a little bit more information on what ancillary charges they're referring to and what exactly they mean by ancillary charges. But generally our approach to network charges is that they are a direct, well, not ancillary charges, sorry, network charges. is that they're a direct pass-through. So if those ancillary charges relate to costs which would be incurred in the normal process of people consuming electricity, it would probably be passed through. But I can't say that for certain without knowing exactly what it is that they're talking about.
Well, whoever posted that question, feel free to pop your hand up if you wanted to speak to it. Have a think about that maybe while I move on, given the time, but I'll keep an eye out for your hand. Another question anonymously, can the Commission step through the historic information it has used to validate that its approach for estimating LRET costs will compensate retailers for costs into 2021? Over to you again, Jonathan, I think.
I would like to anonymously thank our anonymous friends at Energy Australia for asking that question. So look, that's a good question. Basically, what we have done to explore the impact of changes in LGC prices going forward is we've had a look at the cost data that we've received from retailers for both their wholesale and LRET costs, and combined them and see how this compares to the combined allowances for wholesale and LRET costs in the VDO cost stack. So admittedly, this is backward looking information that we're comparing our VDO allowance to. And I think at this stage, that's probably the best information that we have available to us. However, we're open to considering other information. I know that we've received some information from some retailers. However, it's difficult for us to validate that information because they're making assumptions about costs for their competitors which aren't publicly available. So anyway, we are open to considering other information and methodologies. So I would encourage you to, anyone who disagrees with our approach, to make further submissions in response to our draft decision.
Thanks, Jonathan. This might be a question for Dean, perhaps, about timetabling and timing of all of this, but the AER, an anonymous question, AER timetable for approval of 6 months of network prices is by 20 November. How does this impact the timing of the Commission's final decision by the 25th of November? Yes, it's very finely timed. And what happens if the AER approval is delayed? Dean, can I hand over to you for that?
Yeah, sure. Thanks, Kate. Thanks for the question. It's a good one. Yeah, we'll make our determination by the 25th of November, so that's a given. And we are working on the basis we'll have the AER approved network tariffs by the 20th, and that'll give us time to make our determination by the 25th. I think it's fair to say we'll be talking a lot with the AER about how the process is going to that point. I think in terms of any delays, it's something we need to give a little bit more thought to about how that might work in the context of any variations and things like that. But I think suffice to say, we'll put our determination out on the 25th. And if anyone has any views on how you might treat any delays, then we'd welcome those in response to the decision. But we'll be exploring this further as well. Thanks, Kate.
Great, thanks very much, Dean. I did have a question for the ESC, an anonymous one that picked up on Patrick's suggestion that retailers should be the only ones to wear risk, and talks about how does that work with our prohibition on disconnections where retailers are unable to mitigate this risk. And I'll just make a couple of comments on that in terms of disconnection. So there's no prohibition on disconnections at the moment, but there are, obviously the Commission's been working with energy businesses to ensure as much as possible that consumers are connected during this time, and I've been really pleased to see energy businesses' response to that. I think it's also struck the right balance in terms of enabling us and ensuring that customers who can pay do continue to pay. And that was particularly, I guess, of importance during the stage 4 lockdown in Victoria. As restrictions change, Commission will be obviously having more discussions with energy businesses to see what the scope of disconnections looks like. But that's probably my comment on that question. In terms of the next question, there was a question back for Patrick. Put you on the spot again, Patrick. If you don't want or can't respond, just feel free to let me know and you can put it in your submission. But Patrick, do you consider that the advertising for the best offer and how to access the VDO can be removed so that customers pay less for advertising and marketing? I think that was a comment you made. Feel free to add some more flavour to that, or someone else from the team might also be able to add something.
Yeah, sorry, where would the advertising be within the bill?
This was an anonymous question. I'm wondering who put that up. Maybe you wanted to talk to that. Otherwise, Jonathan or Dean. Just waiting for a hand to go up.
I think maybe we can follow that up with Patrick separately if we get clarity on the question, perhaps, Kate.
Yeah. So whoever asked that question, feel free to put some more clarification in the notes or touch base with the team as well, and we'll follow it up. Thanks, Dean. Jonathan, there was a question again about that chart about Gemina and what does that mean for over half? Does that mean over half of retailers are inefficient? Jonathan, did you want to make comment on that one?
Yeah, sure. So I don't think necessarily that the chart indicates that over half of retailers are inefficient. It could be a number of reasons why there are market offers above the VDO. There may be additional services being provided with those offers which aren't in a vanilla offer. So they might be providing some special account keeping service or another kind of ancillary service bundled in the package, or they might just be providing better customer service. I don't know, it could be any number of reasons why you would have a price above the VDO. And if your offering provides consumers value, I'm sure that there would be more than a few consumers who are willing to pay more than the VDO.
Great, thanks, Jonathan. I'm conscious of the time, but I would like to cover 2 more questions if everyone can just bear with us for a little longer, because it's been a useful discussion. There is a follow-up comment from Andrew Mayer from Next Business Energy about that ancillary charges question. So thanks for touching base, Andrew. Your comment was, I'm under the impression that ancillary charges can also include meter and meter reading charges that are generally rolled into retail prices. Jordan or Aaron, that's probably a good question for either of you.
Yep, either John or I. So I think, I guess there's a question there around like whether they are included into the general charges or not. I mean, there's also the case that lots of them are just separately itemised. So I think that would be, I don't think the VDO stops those other charges being separately itemised, like meter reading charges or that sort of thing. So, yeah, I'm not sure whether that necessarily answers the question, but I don't think we are taking the view that we wouldn't allow retailers to reflect those changes in network costs, and that just reiterating Jonathan's earlier response.
Yep, thanks very much, Jordan. Andrew, if you've got further follow-up from that, just encourage you to reach out to the team or make a submission on that. We can have a discussion about it too. So thanks, Andrew. Because there's a number of embedded networks at the table today too, there is a question that talks about the general exemption order. So I would like to just touch on that one. And Jordan, I think you were going to respond to this as well, if that's possible. The anonymous question was a part of the general exemption order, which is reflected in the Energy Retail Code, sets out a number of obligations in relation to disclosure for exempt persons, and what are the additional disclosure obligations required now the VDO is applicable to embedded networks.
So I'd have to go back to the specifics of our final decision for the maximum prices for embedded networks, where we sort of dealt with that. So I mean, perhaps whoever's asked the question, we could follow up afterwards to talk through that. But I think under the particular clause that is referenced, it talks about a few different things, but where we would be coming from there is the information around tariffs and associated fees that apply to the customer. So that disclosure in relation to those. So in terms of the specifics, I don't think we have sort of been very prescriptive in that, apart from saying that certain information should be provided to customers so that they can, it's clear what they're paying and so, and how that complies with the different, the rules that we have set. So perhaps that's a follow-up where we can step through in a bit more detail.
Yep, great. Thanks very much, Jordan. I imagine that there's a couple of other questions and comments through today and some follow-ups. I imagine the team will look at those questions and add some responses to those and perhaps put them on our website so people can access what those responses are after today. Given the time, it's 12:04, so I might wrap up that Q&A session now unless there's a hand that goes up that wants to make a final comment or question. I haven't seen any go up, but the team, please let me know if there's one I've missed. But on that basis, and given the time, we might move to close now. So thank you very much for all those comments and questions. I found it very valuable to hear firsthand the sorts of issues and questions that have been raised today. My fellow commissioners are also online and have listened to all of those. So we look forward to thinking further about those and looking at the submissions that come in through our submissions process that ends on the 20th of October. Just a few key points to take out of today that I've heard. Well, we're really looking for updated data from retailers on the impacts of the coronavirus pandemic on retailer costs, and with the context around what's happening with overall costs. And we're also looking for data supporting the cost impacts of the 5-minute settlements rule. As Jonathan mentioned, we're also happy to discuss further what that might look like, so please reach out. We'd also appreciate views on the Australian Energy Council's proposal for a regulatory period of 7 months, Ben, that you covered off in your presentation, followed by another regulatory period of 11 months. I'm particularly interested in terms of the pros and cons compared to our draft decision approach of 12 months. Of course, any other feedback on our draft decision would be welcomed. And we encourage you to make comments or a formal submission to our draft decision via Engage Victoria, which closes on the 20th of October. Feel free to also email the team at vdo@esc.vic.gov.au. And we will make a final decision and determination after considering what we've heard today and all of the submissions that come in by the 25th of November, with the 2021 Victoria default offer taking effect from the 1st of January next year. It's been some really excellent conversation today, everyone. So thank you very much for taking the time to participate in the conversation. And in closing, can I thank again our presenters today from our team, Project Manager Jonathan Roberts, thank you, John, to Ben Barnes from the AEC, to Patrick Sloyan from the Consumer Action Law Centre, and to my fellow commissioners who also listened in, and commission staff who put today's session together. Thanks everyone for being with us today. Look forward to seeing you again. I'll leave you there and keep well. Thanks everyone.